This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
As promised, we're joined now by Todd Lutsky from the law firm of Cushing & Dolan. The segment here is Ask Todd, and the premise is very simple. You get to ask Todd your estate planning questions live on air. We've got the studio lines open at 888-205-2263. Last week, I know we left one of you hanging, so make sure that you call in early to make sure that you get in line to ask Todd your estate planning questions. Again, that number is 888-205-2263. Phone lines are open, so get all queued up there, and we'll get to you as they come in. Again, 888-205-2263 to be able to ask Todd Lutsky your estate planning questions. Mr. Lutsky, how are you today?
I am doing well, and yourself?
Little tough this week.
What happened?
Well, opened my paycheck on last Friday, and all there was in there was a big thing of parsley.
Yeah?
Wages are being garnished.
Yeah, you got to watch that.
Yeah, it's a real issue. Todd, I want to talk to you about some different kinds of trusts today, just to kind of clear my head on the whole topic. I want to start first with nominee realty trusts. What are they? What do they actually do?
So this is one of the, unfortunately, most commonly used trusts because lots of times, real estate lawyers will set them up for people just because they bought a piece of property, and they'll throw them in there, and they're used just so frequently, but they're so misunderstood. What I mean by that is I know it sounds strange, but they're not really a trust at all. I mean, it's got the word trust in it, which just adds to the confusion. But a nominee realty trust, the word nominee means that it's more of a principal agency employer-employee relationship. So what I mean by that is, and when you put assets in these trusts, these nominee realty trusts, you got to look to the schedule of beneficiaries because it's a complete flow through. So the schedule of beneficiaries is actually the owners. And here's the power they have. There'll be language in the trust itself that says the trustee of the trust shall have no power to deal with the trust property unless directed by the beneficiaries. Well, that means that the beneficiaries really control this and they are really the owners of the property. So why this is so problematic, you say, well, that doesn't sound so much of a problem. Well, it generally is because people put this property, let's say they put their piece of property in the trust, and then they list the schedule of beneficiaries as their kids. And they didn't mean to give their kids the property, but they did just that because they're the ones listed as the scheduled beneficiaries, so they're really the current owners. And why that's a problem is what happens if one of the kids get a divorce while mom and dad are living? They might not even realize they own it until the divorce comes, and I can assure you the divorcing parties will discover that this property is really theirs and now part of the marriage. And you could have parents having to buy out their own home, not realizing they gave it away. And that, to me, is a big issue. So lots of other problems can come with it, but that's just a trust. Look at your schedule of beneficiaries and determine whether or not you've got the right people listed and maybe how to undo it. And they are fixable, by the way. So at the end of the day, folks, that is something that you should consider. Now, let's look at one other thing. In this case, what if you put rental property in one of these nominee realty trusts? If you put rental property into the nominee realty trust and the rent is going to you, mom and dad, you put the rent property and you're getting the rent, well, then you're not entitled to the rent because you don't own the property. And the IRS doesn't tend to like that too much. The IRS says, well, wait a minute, the rent might be taxed at a higher rate if it went to the kids. And they're the ones really entitled to that rent. So at the end of the day, that could be an income tax problem on top of that. So lots to think about with these nominee realty trusts.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. If you've got a question that you'd like to ask Todd about your estate plan, studio line here is 888-205-2263. Again, that is 888-205-2263 to get your question right over to Mr. Todd Lutsky there. We're going to take a quick break here, but when we come back, it is going to be right to your questions with Todd. Again, we got room on the phone lines for you at 888-205-2263. Quick break, then your questions when we return.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. You're listening to Ask Todd with Todd Lutsky on the Financial Exchange Radio Network.
Still got a little bit more room on the phone lines at 888-205-2263 if you've got a question for Todd. But let's go first to Kenny in Tewksbury. Kenny, what's your question for Todd Lutsky?
Yes, I've got a piece of property. It's coming out of an irrevocable trust that was made 20 years ago.
Huh?
There's five siblings, and one sibling would like to buy out the rest. Is there capital gain?
Okay, so it's a question that I can give you an answer to, but understand, not having read the trust, it's complicated for me to know. But here's what you need to look for. I'm assuming that your parents maybe put the property in the trust. Is that correct?
Yes.
And when did they die?
There's one. My mother is still living.
Oh.
I'm talking about in the future. I mean,
Oh.
she's very old.
Oh, okay. So it hasn't come out yet, and it's not coming out till she dies, correct?
Yes.
Okay. So upon her death, you'll have to determine whether or not the assets in that trust are included in her estate for estate tax purposes. What I mean by that is irrevocable trusts are not always completed gifts. So when I take when we prepare an irrevocable trust at Cushing & Dolan for Medicaid nursing home purposes, assuming that's what this was prepared for, was it designed to protect the house from the nursing home?
Yes, with a living estate.
Oh, so you're saying she kept a life estate in the deed, the right to live there?
Yes.
Okay, so they put the remainder interest into the trust and retained a life interest.
Yes.
Okay, that's entirely different. So now I don't need to read the trust. I don't need to know what the trust says, because when you retain the right to live in a property, the government says, yes, you gave away the remainder interest, but you retained the right to enjoy what it is that you gave away. And therefore, the government says you didn't cut the string, you didn't make a completed gift, and the asset is going to be included or pulled back into the estate for estate tax purposes, not for probate purposes, but for gross estate tax purposes. So the full value of that property will be included. I don't know if that's going to push her over the $2 million Massachusetts limit or not, but if it does, then there'll be a mass estate tax. But the good news for you is there will be no probate, or there will be a full step up in basis. So when the property comes out, if it's worth $1 million, it'll be as if the kids paid $1 million. They can sell it the next day for $1 million, and their gain would be zero. So there'll be no capital gains tax when this property is sold, if it's sold shortly after the death of the decedent. I say shortly, within 6 months, 9 months, something like that. So hopefully that's helpful. And that's good news, folks. It's very important to understand these trusts. That's exactly what the new guide is all about this month. Demystifying the 7 top estate planning trusts that I run into. And these trusts are all different. They all have different issues when it comes to taxation, whether it's a gift tax, an income tax, a step up in basis issue like this, whether they're designed to protect assets from the nursing home or special needs children. So this, folks, learn about how these trusts work, from taxation to operations to control while you're living. We're talking about irrevocable life insurance trusts, revocable trusts, irrevocable Medicaid trusts, you name it. The top 7 estate planning trusts are in this guide, and they will help you better design your own estate plan and determine which ones are right for you. So please get the guide, brand new for the month, 866-848-5699 or legalexchangeshow.com. Again, 866-848-5699 or legalexchangeshow.com.
Todd, I've got another caller for you here. Let's go to Hillary in Maryland. Hillary, what's your question for Todd Lutsky?
Yes, I have a living revocable trust, and I was just going to put my property in that. But I also was thinking of putting it in a I guess it's a nominee land trust, but it would be a land trust just for privacy purposes, and then have that trust, my living trust, be the beneficiary of that. And then just, and then upon my death, my beneficiaries, I suppose, would, I don't know if it's hard to unravel once, if you have a trust and a trust. But I was wondering if that's maybe what you're talking about when you're talking about this nominee land trust being a problem.
Well, I can tell you in Maryland, it's probably hard for me to speak to because I'm not licensed in Maryland, but I can tell you if it's a nominee realty trust, yeah, it's that flow-through vehicle. And that's the way you could do it. You could use a nominee realty trust, make the beneficiary the family revocable trust that you're speaking of, and that'd be okay because then it would be in the revocable trust. But, I don't think you need it. I don't think you need that intermediate step is my point, right? You can simply just deed the property directly into the revocable trust. Now, in Massachusetts, we do this. We deed it directly into the revocable trust, and we do not put the revocable trust on record. That's got all your wishes, your family wishes, where things are going to go when you die and how they get there and when they get there and why they get there. That doesn't go on record. A simple trustee certificate goes on record indicating that this trust, this revocable trust, exists so that you don't have to, reveal any of that other information. So I would say my only question to you would be the revocable trust would be enough, not the nominee realty trust. But how old are you?
50s.
I'm sorry, you beeped out. How old?
Late 50s.
Yeah, so I don't know if you're starting to think about protecting assets from the cost of long-term care. If you are, then, I bring it up when I meet clients, 60 and over, 65 and over. So, if you're like 58 or 59 and you're approaching 60 that quickly, you might say, well, why would I want to set up something now that I might just have to, redo in 3 years, 5 years, if I want to protect it from a nursing home. And so if that's a concern of yours at all, then think about an irrevocable trust. And if it's not, then even with the revocable trust, I'm going to mention, don't just stop with putting your house in. So with the revocable trust, I'd put in your bank accounts, your investment portfolio, retitle it to the trust. So it too will avoid probate and get to your family in exactly the manner that you want all those assets to go. Caution, though, one thing you don't put in a revocable trust or a Medicaid irrevocable trust would be the IRA type assets of the world, your retirement accounts. That would be the problem. So don't put those in because those would then create a taxable event on the moment you transfer it to the trust. So just some things to think about, folks. Different kinds of trusts for different objectives that you want to accomplish in your estate plan.
Mr. Lutsky, thank you so much for joining us today.
Always a pleasure. Thank you.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated. Cushing & Dolan are experts in elder life planning and taxation. They know that every family is unique and that every estate plan must be different. Early planning is crucial if you want a stress-free retirement, and trusts are oftentimes the document of choice to help protect your assets. But with so many kinds of trusts, you need to learn about which one is right for your plan. Revocable and irrevocable trusts are most common, but there are several differences, as well as numerous tax implications with each. If you're ready to start your planning or need to refresh an existing plan, call Cushing & Dolan and ask for their new guide called Demystifying the Top 7 Estate Planning Trusts. Learn how to protect your assets and potentially eliminate your estate taxes. Call 866-848-5699 right now and ask for your guide today. That's 866-848-5699 or request it online at legalexchangeshow.com. The proceeding was paid for and the views expressed are solely those of Cushing & Dolan. Cushing & Dolan and or Armstrong Advisory may contact you offering legal or investment services. Cushing & Dolan and Armstrong Advisory do not endorse each other and are not affiliated.